So a few key areas of legal responsibility that business owners should know about or should be doing. Number one, I would say corporate governance and compliance. Oftentimes there are folks that go to the trouble and the expense of setting up a company, but they aren't keeping up with it year over year. And so what that looks like is making sure your annual filings with the Secretary of State are in order, making sure that you're having annual meetings with your owners or shareholders, keeping track of that with company minutes, all the types of things that you would essentially, quote unquote, send to your legal department. Consider sending them to your outside fractional general counsel to support you in making sure corporate governance and compliance are kept up with. Second area I would say is that as a business owner, you are now holding yourself out to the public more so than you are an individual. And so with that, there's just a degree of risk that increases. And so as you are operating as a business, you want to understand the types of risks that are in your space, how your business and corporate structure can help protect you against those risks, and where you may need certain insurance products to sort of bridge the gap. So for instance, if you are a company that is in the medical or healthcare space as a component of what you do, you're probably going to need to carry some level of professional liability, or i.e. malpractice insurance. If you are a transportation and logistic company, you're going to need to carry a certain amount of vehicle coverage on the vehicles that are out there operating on the road. So understanding that your company is built to protect you for risk, but there are gaps and you need to cure over those gaps with appropriate insurance products is another key area of consideration when legally planning for your business. Finally, probably the third area of question that we get the most at NC Planning is just around the financial or the economic planning of the business. How do we successfully operate in a way that's going to help our company grow and succeed for the long term? And that really gets into an area that we call business planning. And business planning takes into account the corporate governance, the corporate structure, the insulation, the protection, the insurance over certain risks. But it goes a step further. It starts really taking a deep dive with the client into what their goals and their objectives are over the next year, 3 years, 5 years, and maybe even what that 10-year vision is. We like to get to know what our clients' objectives are here so that we can help them plan for the future and set them up for success in case there's a acquisition event for growth or perhaps a succession planning and exit event later on down the road. So those three areas, again, I would say are the corporate governance and structure, understanding risk and insuring over it, and then effectively business planning for a successful future. Non-compliance, right, or straying away from compliance, failing to file required filings on time can have an adverse impact on your business. It can be costly in both time and dollars. And so it's really important that you keep up with corporate compliance, corporate filings. The important thing to understand is that you as the business owner have this responsibility, but it might not be your wheelhouse, might not be your specialty, your strong suit. And so you may have a need to have basically your outside legal affairs monitored and managed by a team of professionals and advisors you can rely on. And that's where we at NC Planning come in. We help the business owner take some of those things off their plate and really send it to legal. Let it be on our plate to manage for you. And then you as CEO, president of the organization, it's our job to be accountable to you and report to you and update you of compliance deadlines and next steps to make sure that your business doesn't fall out of compliance. All right, so two areas that go together in discussion a lot are business and contracts. We could probably spend hours in an entire seminar on what are the types of contracts that come into play in business. I mean, it's such a general term, but I like to think of these sort of in categories. And so the first category that comes to mind are the contracts that are necessary for compliance, for the business to be a corporate structure and to operate on a day-to-day basis. Those generally we refer to as corporate governance documents. And so those are things like your operating agreement for your LLC or your shareholder agreement and bylaws for your corporation. Those documents are internal, and they're largely used by the company to navigate different events that come up for the company, ranging from managerial to directives to who has authority to sign and bind the company, to what happens in the event of death or disability or insolvency, these buy-sell events that we refer to. I think of those as sort of internal contracts or agreements that help the company, number one, be compliant with the law, but number two, function and operate on a daily basis. Rarely are you sharing those with anybody outside the organization, but occasionally your financial lender, as you set up bank accounts, will want to have a copy of those on file to make sure that the business is legitimate and has been properly organized or incorporated. The other category I think of when I think of contracts are really external contracts. So these are things that the company is going to engage in on a contractual basis with other entities or individuals that sit outside of the organization. They might be vendors. They might be another company that has a business opportunity like a merger or an acquisition to explore. They might be a potential employee who you're looking to hire and onboard. And so all those relationships get governed by contracts. One of the quickest ways a business owner can fall into a pitfall is by trying to, quote, DIY it or do it yourself when it comes to your contracts. If you are a business owner and you're trying to shortcut the need for contracts, whether it's financial or time or otherwise, you may get it done quicker and you may get it done cheaper on the front end. But what will inevitably happen is it will expose you and your business to greater risk than if that risk materializes into a legal claim. It will inevitably cost you a lot more time and a lot more money on the back end when the claim arises and there's need for settlement or potential litigation. And so in the interest of protecting your business and yourself, it's highly encouraged that you spend the time, the attention, and the resource on the front end to get a good set of contracts in place for what you need so that you can mitigate the risk on the back end and hopefully continue to operate successfully without any interruption. Yeah, so the first thing that comes to mind is when a client would try to save time or money on the front end that then results in a bad experience down the road is really when they try to do it themselves, DIY it, if you will, when it comes to a contractual provision or a contract. I mean, I've had conversations with folks over the years, everyone who has gotten themselves sort of into a situation where they now owe another party a great amount of money because of the way that they wrote a contract themselves, to just interruptions with their day-to-day operations because the business has chose to negotiate and revise contracts themselves with their customers and their vendors in the space. And so, again, there's risk on the back end, but there's also real sort of, opportunity cost in the short term. The business owner is sort of sacrificing their day-to-day capacity in trying to negotiate and redline a contract that they could have just sent to their legal team to get it done more efficiently and allowed them to continue to do what they do best, and that is operate their business and make money. Hypothetically, a business owner might enter into a contract with a co-business owner where they think they're giving them one type of ownership interest or equity in their company, when in fact they are delivering completely fully vested ownership interest or equity in the company. And then travel down the road a little piece and the business owners don't get along very well, and they go through what I would call a business divorce. When you get introduced into a matter at that juncture, you would really like to see a good set of contracts in place on the front end, be able to read those, be able to understand where we are and what the pathway forward is to resolving a dispute, or as I refer to it, a business divorce. But lo and behold, if the business owners took it upon themselves to draft their own contract, chances are, 9 times out of 10 plus, they're not going to have the very typical or prototypical provisions of the contract that we like to see in place that can help you navigate the exit. And so what you're left with, in short, is a mess. It becomes a business divorce really without any type of map or compass. You're going to be lost on how you get from point A to point B, which point B being a successful exit. And that gray area that you now find yourself in is really That's where litigation and contested matters kind of are festering and are bred. You can avoid those types of litigations and contested matters if you've had a really good set of, either an operating agreement or shareholder agreement and bylaws put in place so that you understand how to unwind a company and how to exit in the event of a business divorce. So if you're a business owner and you would like to set yourself up for success and protect your business on the front end, so to avoid risk and catastrophe on the back end, feel free to give us a call at NC Planning. Our team members are standing by and we'd be happy to help.